terrorism, I can only say for sure the space was undetected which end up hurting the country, and the government is left with no interest. They cannot be fraud. Frozen, and therefore the objectives of the we your exposure to national security threats. What I mean, traditionally, a country's exposure to security threats was limited to land, air, and sea. But now there is a fourth frontier of attack, and the nation can be attacked severely and perhaps even more disastrously, in a more disastrous manner from the cyberspace. And so we set up this task force. This task force had already covered a lot of ground and was supposed to expire and submit a report to the Cabinet Secretary on 17th of August this year. While that task force was about to complete its work, two things happened. One, the attempted attack on the e-citizen platform, which paralyzed and interfered with the activities in that platform for a day or two towards the end of July. Number two, Worldcoin. And those two developments led the ministry and the government to determine there is need to do more substantive work and include these new frontiers of cyber security threats. And for that reason, the task force period has been extended for another 3 months, and their recommendations will be able to help us tackle all the gaps in the law and policy around this area. But in the meantime, in a summary, Chair, the gaps at the moment are around the registration of companies, and entities that want to be data controllers or data processors under the Data Protection Act. The kind of documents that are supposed to be presented before a company or an entity is registered as a data controller or data processor, the issues around eligibility for issuance of certificates as a data controller or processor. We believe the law needs to clarify, amplify, and make it a bit rigorous. Not everybody should be able to collect data and control data for the same reason, as I have said. The same way the country's security today is being threatened beyond the three traditional areas of land, air, and sea, with now cyberspace coming on board. The same way, in a similar way, in a similar manner, data is becoming the gold of the future. What gold was to the economies of the 18th and 19th century is what data is going to be. Whoever controls and processes data is going to be holding into very valuable assets. So it should not be easy that anybody can come simply because they have an inducement and start processing the data of people and controlling that data. So the process of registering those who control data, those who process data should be made more rigorous under our laws. Two, foreign companies seeking to become data controllers, data processors, the kind of documents and eligibility criteria should even be harsher. They should be harsher than the eligibility criteria of companies and entities of the people of Kenya. And the reasons are for reasons of national sovereignty. It is actually something we need to reflect on. And I know, Chair, I've had this discussion elsewhere in a different space. Data being what it is today, a crucial asset, a crucial tool that can be used not only for good purposes like commerce and business decisions, but data can be used to harm. So a foreign entity, a foreign company, or even a Kenyan company or entity which is associated or has allegiance to a foreign entity must be treated with a lot of rigor before they are allowed to process, retain, and control data of the people of Kenya. What worries me as the minister responsible for the security of our country in this particular matter was the kind of data that was being harvested. Because the iris, the scanning of iris is one of the most intrusive data harvesting methods. There are other methods, but the scanning of the eyes is quite intrusive. It's deeply intrusive. Number two, experts say that the biological consequences of that intrusion, it could be disastrous. It could be life-threatening. So from where I sit, Chair and members, I think we should be very careful with allowing foreigners to access, control, process, and retain the data of the people of Kenya for the reasons I've given. Number three, the current law does not pronounce itself on circumstances when data controllers and or data processors give incentives to induce subjects to provide data and the punishment for inducement. In other words, should a data processor or controller use an inducement as a way of obtaining the consent of the person from whom data is harvested? And therefore, the question that in our investigations we would want to establish is, besides the gap being there, is whether the consent of the Kenyans that gave consent for their iris to be scanned was informed consent, voluntary consent, or it was consent obtained through inducement and undue influence. And the lawyer's chair will tell you that whether or not the consensual contracts were signed, the contracts of consent, any contracts obtained through either duress, inducement, or fraud, misrepresentation, all those contracts are avoidable and they can be rescinded and they can be avoided etc., etc. In other words, Chair, it is not enough. First of all, we must ask ourselves as the people of Kenya that if I come and I'm processing or harvesting data, and instead of asking for that data and asking for the consent, I have some money in my pocket. And I tell the people of Kenya, I have some money here, but please, you must allow me to do this. Is that lawful? Is that even moral? Is it something that we should allow as a country? Next, the Act does not provide for specific proof to the commission, the data commission, that to ascertain itself that the subjects of data collection were taken through the purpose. The people whose data is being collected. It is not clear, neither is the commission obligated to ensure that the public in whose data is being collected is thoroughly made aware what the purpose of that data would be in the short term, in the mid-term, in the long term. Next, enforcement and issues around enforcement of this act on data protection needs to be enhanced. And now that the laws of Kenya are silent on cryptocurrency, which is currently one of the most popular financial tools for organized crime, based on the reports from other countries, other jurisdictions. We should ask ourselves whether cryptocurrency should continue to take place without regulation, without the CBK oversight, or we should recognize it and regulate it and move on. The gray situation we are in, our continuous maintenance of a middle ground is not helpful to the country, and it threatens both our security and our sovereignty as a country. Honorable Chair, as I have said, the Ministry of Interior has established the task force which has been established under the Computer Misuse and Cybercrimes Act of 2018. And we are going to attach very, very detailed regulations on enforcement of or further administration of that act. The drafts are ready, public participation is ready, and we are going to include these new challenges that we've gotten from the attack on the e-citizen platform and the Worldcoin issue to make sure that we take on board comprehensive reforms. Finally, Chair, the following are the recommended areas of intervention. One, there is need to consider and redraft criminal offenses. The criminal offenses section under the Computer Misuse and Cybercrimes Act of 2018 to remove duplicated provisions, to delimit the scope of the offenses, and to better specify the objective and subjective elements of the crime. In other words, that area of the Computer Misuse and Cybercrimes Act of 2018 on offenses is scanty. We must develop two things there. One, we must expand the scope of the possible crimes which can be committed under this law on computer misuse and cybercrimes. Number two, we must also provide and develop what lawyers call elements of the crime. We must provide for both the objective and subjective elements that constitute the crime. That is the only way to capture everything. Because today is Worldcoin. Tomorrow there will be another thing which is not covered in the law. And my experience tells me, beyond just criminalizing certain conducts, we need to go further and develop the elements of the crime in such broad terms that even in future, a new activity would easily fall under the expanded and elaborated section on crimes under this cyberspace. Number two, it may be possible for Parliament to actually take on this issue of cryptocurrency even in a separate act of Parliament. Okay, and just perhaps for a run for the rest of the world and how we need to handle this matter of cryptocurrency. The current law does not distinguish between serious and less serious types of harm, which is worrying for me from my legal background. It tends to treat, the current act tends to treat violation of computer or misuse of computers and cyber crimes like conduct which falls in the same hierarchy. I have already demonstrated, Chair, to this committee that even when it comes to violation of data privacy, depending on the methods used and the procedures used to harvest data, you can create a hierarchy of crimes because some of the conduct is more intrusive, it has more dangers and more risks on the victims, and therefore we require to have a hierarchy of crimes so that we distinguish between small crimes, medium crimes, and what we will call egregious crimes on this cyberspace. And penetrating, for example, somebody's eyes with electronic equipment, harvesting that data and storing it as huge biological and chemical consequences and health implications. And that's part of what our investigations should help us to establish. Finally, I think we need to establish the National Cybersecurity Agency under the Act. This agency should help us to regulate the cyber space and act as a bridge between industry and government, and provide a unified source of advice, guidance, and support for cybersecurity, including proper management of the cyber space. We need to amend the certain provisions of the National Intelligence Act number 28 of 2012 to address digital economic sabotage. Now that we've moved to e-commerce, e-government, e-services, we need to empower our National Intelligence Service Agency to be able to rein in on the cyberspace and be able to intercept activities and data in the cyberspace to avoid a situation of digital economic sabotage. We also need to amend other laws, including Access to Information Act of 2016, to incorporate strict parameters on extraction of information by digital internet-based companies. The Access to Information Act needs to be amended in that respect. And then also there is need, as I have said, to think whether time has not come for us to have a standalone Cryptocurrency Act of Kenya. Thank you, Honorable Chair.
So thank you so much, the CS, for that very in-depth and elaborate discussion. You've actually gone a long way to try to really outline and pinpointed the gaps in our existing laws. to address the same. Now, maybe before I go to the plenary and give members to contribute, it has now been in the public domain and it's obvious. We had the Worldcoin actors, actually the real guys seated where you are last week. And they confirmed to this committee that to this end, there are about 700,000 Kenyans, actually close to 1 million, because the subscriptions or the onboarding on listing is still ongoing online, who's already given out their data to include the 350 plus whose Irish were actually taken. As the Minister of Security, and of course, given even your background in law, you're a law excellent. We have, within our existing laws, do we have got possible means of retrieving or deleting the data of Kenyans which were already been harvested and stored in what they call the cloud and actually sent to a place, the Worldcoin Foundation, they say it's in Virgin Island, and they confirm actually to this committee that that data has been already transferred and sent to the foundation in Virgin Island. Within our existing laws, being the Minister of Security and Interior and being a lawyer of international reputation, which means and possible means do we have as a country to retrieve such data? Secondly, taking into account the admission that already this space of cryptocurrency is a very fertile ground to finance the terrorism. Which measures do you think we should put in place to avoid the same? We had the DG from the Center for Finance Center reporting there yesterday, and he had given an example of the very famous guy, crypto player, who sent 300 million to 3 girlfriends in the country. And we only managed to actually forfeit from one recipient. The other 2, they managed to take their money just because the lawyers went around the law and the government could not really able to have the money forfeited. What do you think the measures that we should put in place to avoid such? And I'm going to give 3 members plus the 2 questions to raise their concern, and we are going to go in that order. And I will start, of course, from the petitioner, Mukunji, then Gideon, Ikana, then we take the other bunch, starting from my vice. And I will ask members to try to be to the point, because it's already one.
Thank you, Chair. And I want to start by thanking Waziri for quite straight to the point a report that really touches on things that we have been deliberating in this committee for a while. I also want to thank him for being the really first one to come out clearly and condemn that issue and take the necessary steps that he took when the issue came to the attention of the nation. Chair, I was very keen when Waziri was pointing out areas of interest in terms of the law change. And one of the areas, Waziri, that really touches on this is the issue of registration of organizations in this country and their functionality. I know it is not under the Ministry of Interior how companies come here and mine data. And Waziri, one of your recommendations is you being involved in the uptake of companies in that. Please, I would like you to tell the committee clearly on what department would you like to see getting involved when companies are coming here to do their businesses, because we have had challenge where a company has come and taken Kenyans for a ride, misused Kenyans, and it has left. We are left investigating. Chair, also on the same, this country is one of the countries that are able to be really ahead when it comes to take up of issues, internet. We are way ahead of many African countries. There is a very thin balance, Chair, on being very strict with our laws and the appetite the foreign companies have in terms of coming here and setting up business. And that has been very something that has attracted the country to companies such as Worldcoin and the rest to come and try their things in Kenya. I believe you are also the minister in charge of rolling out the Maisha digital card that is coming up. So are we having a double speak on this issue? Because this country also want to have a digital identifier that is strict and uncorruptible, but at the same time, we are chasing out companies that are ahead of us on this. I would like to get that from Waziri. The other question and the last one, Chair, is while the investigations are not yet done, and we know very well we have had a case where this company, as you have said, started mining data way ahead before they even mentioned issues to do with registering in Kenya. Could we not have had already arraigned some in court? Because obviously, even before the conclusion of this investigation, we know already law was broken. Kenyans were misused. Are we still in that part of investigations until the public is not following on this issue keenly? Or are you giving us a guideline that we are going to see hands rolling possibly as soon as today or tomorrow? So I would like to hear that. There is the issue of NC4, which I know your ministry or yourself are part of. Is it effective? And what is the problem with the fact that we are still talking about this, whereas there is a setup that was already in place, a multi-agency that has been working since the act was passed? Chair, I think those are my questions. Thank you very much for the opportunity.
Gideon, in that order and to the point, please, so we can accommodate everyone.
Okay, thank you, Chair. Waziri, thank you for your presentation. I have a few questions. The first question I want to ask is, when the data commissioner came here, and even the minister for ICT, they told this committee that the operations of Worldcoin actually started way beyond 2021. That it's not just what we saw, the queues at KICC in August. So my question to Waziri, why did it take very long for your ministry, to tackle this issue of Worldcoin until now when we saw the long queues at KICC? So does it mean if we didn't see the queues at KICC, or if Kenyans had not made noise online, or if the petitioner had not brought the issue at Parliament, so this issue of Worldcoin would have been swept under the carpet. Does it mean somebody at the Interior Ministry was living on his job, maybe the DCI or who was supposed to have told Kenyans these issues? And that takes me to my second question, which my colleague has asked. The Computer Misuse and Cyber Crimes Act of 2018 establishes a committee called NC4. NC4 brings together the PS Internal Security, the PS ICT, we have the Chief of Kenya Defense Forces, the Attorney General, we have the Inspector General of Police, we have the Director General Communications Authority, Director Public Prosecutions, the Governor Central Bank, and the Director NC4 Secretariat. What is the mandate of NC4? One of the functions of NC4 is to advise the National Security Council on computer and cyber crimes. Number two, to advise the government on security-related aspects, touching on critical information infrastructure and the new and emerging technologies, and they have quoted there blockchain, 5G, AI, and the Internet of Things. Where were these people? Because we are now talking about blockchain, we are talking about Worldcoin. Where was that committee? And to ask the same question my colleague has asked, should we disband that committee? Because even if we are coming up with the new regulations that you've suggested to us here, when the NC4 Secretariat came here, they blamed their bosses. They said they are just the Secretariat. These things we take to our bosses. So does it mean their bosses didn't do their job? Finally, in your statement, your first statement, you've told us these people of Worldcoin, they came here as Tools for Humanity, corporation registered in the United States. And the other one is Tools for Humanity, registered in Germany. You've told us they commenced data collection and processing activities in the country in the case of offering educational programs on cryptocurrency. These people came here, Alex Blani and the team. They told us they were not supposed to acquire certificates to do business in Kenya, because in the Data Commission Act of 2019, they are just supposed to get the permission from the Data Act, and after that, they don't have to get other permissions from the government. I want to ask this Waziri directly. Waziri, are you confirming to this committee that these people were operating in Kenya illegally? And if chair permits me, maybe I can get a yes or no answer on that.
Just follow the earlier communicated order. You will take the three.
Just that one only.
No, you will let him do the same,
Okay.
practice. We give the practice. So if you're done, you can do, then you can pick.
Thank you, Chair.
Thank you.
Okay, thank you, Chair. First, allow me to most sincerely thank and congratulate Waziri Professor Kindiki for emerging the top in the latest rankings that we saw in the ministries. Congratulations, Waziri and your team. To my first question, Waziri, I wish to know the role that your ministry plays in the monitoring of financial inflows and outflows, because there are indications that these Worldcoin guys might have brought into the country huge amounts to the tune of around 2.5 billion shillings. Did these monies come in undetected? And if you have now commenced any forms of inquiry in establishing the source of these funds? Then finally, is a very brief question. Waziri, are we at war with technology? Thank you.
So Waziri, you can take a question for the three members before we let the other set.
Thank you, Chair. And thank you for the members who have raised the supplementary issues and seeking clarifications, including yourself, Chair. I'd like to respond as follows. When the Worldcoin matter became public, the government ordered cessation of all activities relating to this company in terms of collecting data from Kenyans, dealing with it, disposing that data with immediate effect until we get to the bottom of this issue and find out whether the operations are within the law or not. We also went to court through the ICT ministry and obtained court orders against this activity, the continuation of this activity. If the company has come here and admitted that they are continuing with that process, then they're in contempt of court, and they have admitted that they have no regard for the law of Kenya, and that court order meant nothing to them. If that is the case, I hope it is not. But if that is the case, that is the clearest sign of impunity and disregard for the law of Kenya. And if it is the case, we will deal with it immediately we leave this room. As to the question whether data stored in the manner in which the data we are talking about here is said to be stored can be retrieved, we are getting two conflicting expert opinions, because this is science. It is not black and white matter, it's science, it's scientific thing. So we rely on expert advice. On the one side, most of the science, the experts in this area are saying that actually data, even data in the cloud, can be retrieved and deleted. But there is a different opinion, again from experts in this space, saying even when it is deleted, there is a way that data, once it's in that space, cannot be completely and with certainty be retrieved. So from where we sit, that is the information I have at the moment. I want to be on the cautious side as the Security Minister of Kenya. I would rather side with the possibility that when data enters that space, it cannot be retrieved completely, because that is what would put me on the safe side in terms of going forward. And this would inform the kind of regulations we put in place in terms of who we allow to harvest data, to have it, how they will store it, and where, in what circumstances. I want to side with the minority of the scientists who are saying that it is not possible to retrieve data which has been stored in the cloud. So from where we sit as government, there should be no more registration of people on anything related to Worldcoin and all activities and other companies
Waziri,
associated
while
with this.
still at that, you know, you're speaking as the CS, the Minister Security, but you're still a lawyer par excellence. Within both the local and international laws framework, do you think we stand a chance of maybe forcing the Worldcoin owners to retrieve Kenya's data?
Yes. Yes. But we need to do a lot of work. And jealously guard, based on the case I made earlier on, 2 points, Chair. One, that data is precious. And two, the nature in which this data in question was harvested is an extreme. It's allowed, yes, but for a foreign entity to choose that method and have access to that data and store it in the method we are talking about, we need to be a bit more rigorous in terms of demanding some levels of accountability. But to answer your question, it is possible. The other question which has been raised is on cryptocurrency and financing of terror. And Chair, you raised the issue of the crypto dealer and the girlfriends. It was possible for the regulatory institutions of the country, in this case the Financial Reporting Center, to detect the money. But it was only possible when that money was converted, or because it's a way in which it found its way into mainstream financial assets of the world, and it left Belgium and came to Kenya into the bank account of the girlfriend. And the challenges are as follows. First, to money in terms of legal tender coming from abroad to a bank in Kenya can be traced, and that's why it was traced. And even the other two, it's only that they had accessed the money. And there could be reason perhaps why that happened. Because again, the purpose of surveillance on financial inflows and outflows is not to prevent people from running businesses and doing their things. It is to ensure that financial inflows and outflows through our country do not perpetuate money laundering, trade in drugs and psychotropic substances, and terror. Otherwise, it should not be the business. It's against good economic order to have too much surveillance on citizens and who gets how much money. And if that money is not perhaps suspected to be geared towards doing those criminal things, that surveillance should not be overbearing. It would hurt commerce. Now, we are very keen on inflows and outflows of finances to our country for the reasons which we all know. We have been attacked severally in this country, and those attacks could not have succeeded without a financial element somewhere. Differently put, Chair, the engine of terror, what drives terror is money. If you remove finances from terror, the terrorist has no power to achieve the objective. And therefore, my challenge, and I need to be convinced, because this is national debate. This is national debate. The reason we are here is because these are new frontiers. The legal framework is not adequate. There are no hard and fast issues. But I need to be convinced, as the security minister, I need to be convinced that if there are gray areas and we cannot pinpoint the owners of money and how they have made that money at that crypto trade level, until that money finds its way into the the form of financial structures, like the case which we have given of the person who sent actual money, not now crypto tokens or whatever. Actual money was sent to an account in Kenya. That's what we can trace. But this other the crypto business and trade, the traceability is a problem. Then, at the risk of being accused of being at war with technology and commerce, I will be reluctant. I will be reluctant to say that that is an area we want to venture into, because the cost, the price of a successful terror attack can wipe away many years and decades of investments in our national security. Then, Chair, I've been asked about the security vetting of companies. And I want to say directly that, especially depending on the type of, all right, let me rephrase my response. At the moment, there is no requirement that foreign nationals who want to do business in Kenya or want to associate with businesses doing in Kenya must necessarily be vetted, although we do it. We sometimes do it when we have reason to believe. But there is no law, and also, as security agencies, we would not want to intrude into commerce unnecessarily and make it difficult for people to do business, because we are a country that has trade relations all over the world, and we're encouraging investments and business, etc. We do it when we suspect, when we have reasonable grounds to suspect these people who wants to register a company could be suspicious characters. But if I were asked, it should be the norm. Because at the moment, even for locals, right now it's very easy to register a business, and that's how it should be, because we are judged by World Bank and other agencies that on ease of doing business, but by how fast someone who wants to do business is able to incorporate the business and start working. But for the people of Kenya, that vetting can continue as they continue doing their business. At the very least, for foreign nationals, I think security vetting must be a priority and a precondition for the relevant permits to be issued. It's good for the country, and we can have a way of expediting that vetting so that it doesn't also take unnecessarily long period of time. And that vetting, because I was asked about which agencies, should be two-pronged. One, the ordinary way of the good conduct by the DCI, but also NIS vetting, which takes into consideration other factors beyond whether or not somebody has committed a crime in the past, because DCI concentrates on good conduct in terms of whether somebody has a criminal record or not. And so, what has worried me from this interaction with the committee is if there is a possibility that the directors or officials of Worldcoin came here and said that despite the stop orders that I issued and the court orders that were issued, they are in any way dealing with Kenyans and interacting with Kenyans in that space. Let me put it this way. I wish I had gotten that information earlier, because he would not have left the country. In fact,
Just
it
to,
is,
as
it
an
is,
information,
it
okay.
is, it is, it is important to say that I don't like how lightly we want to push commerce and trade ahead of security matters sometimes. And I can share with you that we allowed the Worldcoin officials to enter and leave Kenya after an undertaking by the American government that they will produce them when we need them.
Just as a point of information or clarity on that, I think the matter of ongoing subscription or onboarding is not really the physical one that we're doing in malls or KICC.
Even
It's still online.
we
the
are
app.
clear they should stop all
Yeah.
activities
Yeah.
related to that matter, not just the scanning of iris.
I was-
Because if, for example, it is the case that they have violated our laws, what business do they have doing anything else that is lawful?
Chair, just one additional question on that issue, specifically that issue. I have seen in many jurisdictions, Dubai, China, they are able to limit certain ISPs in certain areas. Especially if you go to Dubai, it's very easy. It's not easy to use as something like WhatsApp. Why is why are you not taking that direction, Bwana Waziri? Thank you.
I'm entertaining the thought, Chair. It's good advice there you've given. I am yet to be convinced that that activity is a safe activity. And the government of Kenya did officially communicate on that matter. And the issue of the officials of Worldcoin, their departure was based on a firm and formal official agreement by the American government that if we require them, they'll produce them.
So Waziri, just on that, to make it is like we are talking about with collaboration with the other government agency, until proven otherwise, we can look ways of deactivating the app within the region until the Kenyan government see the need or the reason of having it ongoing.
Very well. Chair, I've been asked about the NC4, which is the National Computer Coordination Committee. I think by and large, that committee has been effective. But part of the reforms that we had started, the reason why that task force I have stated was established was actually to strengthen and place greater accountability on the outfit and see perhaps how else we can firm up the mandate, what they are doing. And as you can see, the mandate that the member led is advisory mandate, simply advisory, and for good reason, because cyber security, just like other national security threats, must end up in the National Security Council as part of the architecture of our national security. But I think it's a bit, I would not be in order to say that this organ is not important. It's technical level experts, the CDF, the IG, the heads of agencies that really help us get information that can be escalated to the National Security Council. Now, I'm also not in the blame game thing. In my view, is not the way to go for a country. I think unless where we isolate a particular institution, a particular public official who has through negligence or through commission has done something, let us agree this space is a space which even the most complex economies are struggling with in terms of having a total grip. There have been cyber attacks in some of the most developed and sophisticated countries, perhaps not in the magnitude in which there has been in our space. Yes, one of the members, I think, asked about what this committee was told before by another witness, that the company in question came here and according to them, they were not required to get any permission, except being allowed by the data commission to continue with the activities. My understanding is that this company was not providing any services directly within Kenya. And that's something else we need to interrogate even as we look at the oncoming reforms, because the cyberspace is the threats in the cyberspace can actually take place extraterritorially. Somebody doesn't have to come here and set up a shop to harm the people of Kenya through the cyberspace. They can be in Iceland, they can be in South Africa, they can be in any part of the world. So, as to the question whether or not they didn't need any other authorization simply because they were not directly working in Kenya, is something that perhaps I don't agree with. But the member has asked me to say yes or no to his question, which was whether they were acting here illegally or not. I am not in a position to give that answer now, but I should be able once the agencies conclude the investigations, because I will be prejudging, I will be preempting the investigations and passing judgment. And then we have the law, we have the constitution, we have the presumption of innocence. And that's why we have not detained anybody until now. And on the other question, as I go to finish, which was asked about why we have not arresting some people by now, I've just asked for patience so that we do something holistic. I know this country, there is a tendency for the public to be thirsty to see somebody, getting arrested in a dramatic way. And I plead, but this is a sophisticated crime requiring a lot of science. It doesn't help. And I think what the people of Kenya want to hear now is not that somebody has been taken to court for some small misdemeanor or administrative lapse. They want if it is true, there are people who using the cyberspace have caused harm or attempted to cause harm on the public safety and security of the people of Kenya. Those bearing the highest responsibility, I would think our target should be on those ones. I think finally we are not at war with technology, but we will not allow technology to hurt our country at whatever cost. We will not fight technology, but we will not allow technology to hurt the security and the safety of the people of Kenya at whatever cost, not even through inducement. The fact that the people of Kenya are getting some coins should not be a reason for a government to legitimately allow the exposure of that public, even with their consent, to get harmed. Thank you, Chair.
So thank you so much, Waziri. You're going to take the other round of three, starting from my vice, Irene Mayaka, Shabir, and Kaluma.
Thank you, Chair, and thank you, Waziri, for your elaborate earlier presentation, especially on the legal recommendations. First of all, on the issue of disengaging the application, you might want to also consider using the services of the ethical hackers, or white hat as they're called, within your state security operatives, to also check if there are any Kenyans who have access to VPN services, especially from the US and Australia, if after this has been disengaged, if they can still access it, because that's very important. The first question I have, and you did speak to one of the suspicious transaction in relation to cryptocurrency of the man who gave transferred monies to his girlfriends. But there's also another similar issue that is currently in Milimani court involving about USD 3.3 million. What I want to know, Aziri, is taking this into consideration and all the matters that you did allude to, can you provide information on its coordination efforts with international organizations or foreign governments in addressing cross-border cryptocurrency related issues? And then secondly, Waziri, I don't know if you've had an opportunity to have a look at the Worldcoin data consent form that's online, which when the team was here, they did mention that they had Kenyans agreeing to the terms and conditions online in the application. And I just want to draw your attention to some of the things that are in that form. Number one, it does say that the consent to process personal and sensitive data for transfer to another country. More concerning for me is that they do say if you give us your consent to collect your sensitive data by photographing your iris, your face, and your body using the orb, we will transfer your sensitive data to our teams in the United States, India, Japan, United Kingdom, and Germany. And our research and development facilities are located in these countries, and that we are unable to operate the software we use to process your sensitive data within your country. They also allude to the fact that as a result, we may transfer and store your sensitive data in part in the US or elsewhere where privacy laws may be less protective of your data than the laws within your country. And they even go further to say that they do recognize the European Union GDPR, that is the General Data Protection Regularity. On the risk of transfer, they further say, if we share your data with any third party outside your country with or without your permission, that the third party may not be subjected to the GDPR or the data privacy laws of your country. And if the third party decides to use the share your data for purposes not described in the consent form or in your privacy statement, it might be difficult or even impossible to assert your privacy rights within that. Part 4, they say in terms of consent, and I'd just like to mention that some of the things that they were able to collect. We will collect the following sensitive data: high definition video and photography of your body, face, and eyes, including your iris, contactless Doppler radar detection of your heartbeat, breathing, and other vital signs, and 3-dimension mapping of your body and face. But then again, yesterday, one of the co-founders of Worldcoin, one Alex Blenia, while in a conference in Singapore, when he was asked about privacy concerns, he did say that Worldcoin doesn't store the data once the iris scan is done. your data is deleted, you actually stay completely anonymous, which is a very, very powerful thing, given I do believe that we have figures, we have to figure this out globally. So this in essence contradicts what Kenyans had signed to. So what I want to know is, within your scope and within your responsibility in terms of safeguarding our country, even on personal data, and because of what they have said, are you in a position to ask them to open the server and confirm that they've deleted the Kenyan data as they are stating? Thank you, Chair.
Chair, with your permission, sir. Thank you, Bwana Waziri. With your report, Bwana Waziri, there are certain things that I need to still confirm. Upon instructions, 48 OBs were taken into custody. One or two of them were sent for scientific or other research. Questions that I have still: how many? We know the OBs came into the country on DHL. What was the declaration made? And I understand the declaration was made that this was just scanners, which was a false declaration because these are not scanners. These are scanners and communication. It has communication ability, which would have had to be type approved by the communication authority. Mr. Bonai CS, if I try and bring a drone into this country for my child, at the airport we are stopped. These guys brought 48 highly sophisticated equipment. We have now got them. We know who brought them. We have the documents. We know what, we want to know how much tax was paid. Was the tax paid fraudulently? Was it irregularly paid? Was it paid like if I bring in a Mercedes Benz and I say it is a bicycle, yes, and I pay the tax on a bicycle, does not mean that the Mercedes Benz is now valid. So what was it? Spy equipment? What do we do when we have stuff like this coming in? So the question we have to ask is this: I know you said that we don't want to go for the small fry, but there are people who have got away with simple things. Now we are going around and taking a chicken, somebody steals a chicken and we put him into prison. What about these guys who brought all this? Because they're here smirking. Mr. CS, they were sitting there smirking at us. If you know the word smirking, utadu, utadu. So the question is, what are we doing? Then the other day we had 11 so-called operators who, if one of CS, if you are taking stolen equipment and you are dealing with stolen, if somebody steals my phone and takes it and sells it 3 times over, you will still go and get the guys. Now, what are these 11 or so local persons? What are they doing here? The other day they were sitting in the parliament, our August house, and they were saying, we don't know this, we don't know. These are companies that are dealing worldwide. Sense marketing for one. They do marketing for all over the world. And they come and lie to us blatantly. And Utadu, because I remember asking them, you told us that you don't ask information. It turned out that they do ask information. They ask for your ID. They ask for certain things. So we are saying, as much as you are saying that we are looking at it and we are looking at it and we will bring in those people. But I think if you can tell us, these guys who are going around saying utadu, what are we doing? Then we understand $10 million, two investors in Kenya invested $10 million each in the Worldcoin in 2021. Utadu, They are saying, we invested. We asked the guys, who are they? We don't know. I mean, surely, how did they invest 10 million? From where? In cryptocurrency? Mr. Mr. CS, sir, I am of the firm opinion that there are some very powerful people behind this thing. And this has been orchestrated since the year 2020. We have had some very powerful people and a very important people coming over here, meeting some very, very important people, technologists, people who have come in the communication field. And we are finding that these guys are covering. Now we asked a question, Bonasias, whether you stole 1 shilling or 1 million shillings, each is a theft. We have been able to produce, sir, 2 cases at least of people who have claimed and have shown us by way of documentation that they got money through, I don't know, pen pal or Pesa what, and it was converted by our own M-Pesa to local money. Is it a laundering? Because 350,000 people got those coins converted and paid in cash. Then we are told, oh, this is 2.5 billion is peanuts when we're talking about how much Safari M-Pesa converts every day. It is not peanuts we don't mind if it's peanuts, but the question we are asking you, Bonasias, if there are 350,000 people got some money from wherever it came, from the cloud or however it came, and it was converted by M-Pesa, isn't M-Pesa doing money laundering here? Isn't M-Pesa trying to get maybe anti-terrorism funds? We don't know. There's nothing. Maybe it's a straightforward thing. And they use other people's names. They don't even use M-Pesa. They use Onyango. They use Wangai. So who is paying who? That's the question. And how did they pay the $10 million each? Wanna see us? Here is somebody claims that there are 2 investors of Kenya have $10 million each in Worldcoin. There's a major, and Worldcoin raised $115 million. So $10 million each is $20 million. 20 million out of 150 is for 20% of Worldcoin is owned by Kenyans. Which Kenyans? Thank you, Mr. Speaker. Yes. That's what we want to know from you, sir. We want to know that. We want to know who did it. Thank you, sir.
Was the other Kalma?
As Chair, time is gone, but allow me to just emphasize the issue Honorable Shakil is speaking about. Waziri, we had the CS in charge of ICT just where you are seated the other day. And both in word and in writing, I think we have the document here. He said these people came to the country in 2020, 2021, and started this business of collecting personal data, even before registration. That they were told to cease business, they continued. And your counterpart in charge of ICT indicated that even despite having been issued with a cessation notice, the data commissioner subsequently went ahead and registered them. The data commissioner was also where you are seated, and she confirmed subsequent to that registration, there is a cessation order and an enforcement notice. But these people are still collecting data virtually. And they confirmed it, including their operator in Kenya, I think something called Sense Marketing. Makes me join Honorable Shakil in asking, who is protecting these people? The DCI serving under your ministry, though under the independent police, was also there, confirmed to us the structures for dealing with these people, and told us the travel of these characters was restricted. They could not leave the country. And on assurance, this committee was very pleased at. You now tell us there is an undertaking, they have gone. And you see how helpless we looked as a committee. Section 974 of the Companies Act says a foreign company shall not engage in any business in Kenya until they are registered with the Registrar of Companies. And Waziri, you know, subsection 3 of that section makes it an offense for a foreign company to do so, and sets out some very good punishment against the company and people running the company. In spite of that, these people, even pending those detailed investigations into whatever money laundering, the possibility they could be facilitating terrorism and those deep ones, cyber security issues, these people were free walking around here, and they have been exited from the country without being taken to court. Why are we applying our laws selectively in favor of these people? Something so clear. Why do you believe, and why, what would you tell the committees the reason as to why the law enforcement agencies under you are not acting, even when law is clear and law is being, violated in the manner mentioned? Lastly, Chair, there is a court order on preservation of the data these people took. I think that is the order that is there. And the DCI was there, confirmed to us there is a whole structure, both local and international, undergirding around security. Would you just confirm to the committee that this being sagas under you, particularly the DCI and those networks, regional, continental, up to Interpol and other agencies, I think we had a report here. Could you just commit to this committee that we could retrieve the data of these Kenyans, which were taken on, in my opinion, the negligent approach to what the law already prescribes? And I'm saying this with utmost respect, Waziri, you're my senior in matters law. But these things of, we need a law to set this, we need a law to set this, we need a law to set this. Look through Section 4 of the Data Protection Act, Section 5 of the Data Protection Act, Section 18 of the Data Protection Act, Section 16, Section 15, Regulation 5, Sub-Regulation 2 of the Data Protection Cybersecurity Regulations. They are all there already. These things you are recommending. And the Data Commissioner is empowered to seek the support of any agency, whether NIS, whether DCI, whether you as a ministry in the discharge of their mandate. There is actually no legal gap. And yet we have these legal gaps. The question is, can you ignite the powers under your ministry through particularly the DCI so that we retrieve back this data? I'm saying this because data is a big business, Waziri, and data can be put into good uses and data can be put into bad uses. This is the area of artificial intelligence. I just imagine there is a world ID, as these Worldcoin people were confirming before us here. And somebody wants to pick me out of this country. It identifies you so well, it cannot even take your look-alike because it is the iris. I'm walking on a street somewhere and you are picked by drone. So they need you for extradition. They just pick you and go on. And therefore, I agree with you. This is more of a security business than it is mere commerce. What can you do in terms of your undertaking to this committee? Because it's a serious position this committee is taking that we must get this bad data back. How do you help us to retrieve this data back? I thank you, Chair.
To you, Bwana Waziri.
Thank you, Chair. I have taken some of the comments or advice on how we need to perhaps implement the law as it is. We are working closely with the International Police Organization, Interpol, to deal with the extra territorial jurisdiction issues that may arise in the process of this work. And I have read the form that was read out by the member, I think Honorable Mayaka. And I agree with sentiments that is quite disturbing. But on the other hand, I am aware that many people, not just in Kenya, in the world, do not read even some of these things. They do not read those kind of things. And that brings me back to the question of what I had raised earlier on in terms of the nature of consent. Is it informed, deliberate, voluntary consent, or was it consent obtained by inducement and so forth and so on? And as much as I want to agree with the Honorable Kaluma that the current law could still help us, I still believe there are areas that we need to improve, including both the criminal offenses section and the elements of those offenses. In either the act or the regulations, but I agree with him still. We have a lot of areas that we could implement and still achieve some results. What also intrigues me in that consent, the details of that consent form that was signed by our people, was the deliberate exclusion of the jurisdiction of the laws of Kenya on our citizens, which on a matter like this, it should not have happened. That would have been something that should not have been allowed by the authorities, by government, because data, especially data in the manner in which it was harvested here, is citizen data is a sovereignty issue. It's a sovereignty issue. So that exclusion of the applicability of the laws of Kenya, for me, appeared to be offensive in that consent form. I've also been asked to tell the committee why it took us too long, since this entity appeared to have been operating, although indirectly, for 2-3 years. And the answer is simple. As security managers, it is not in our space to lord over private or business interactions of people. And I said that last time I appeared before the plenary of the National Assembly. That is my view. That's what I believe in. Our work is to provide the policy context in which business and private matters operate. And unless something has been raised, either through a complaint or we have reasonable grounds to suspect those interactions are violating our law, then that's when we come in. So for a long time, and what actually triggered us was the queues and the complaints. Beyond that, we left it to science and commerce and business operations and transactions. If people are within the law, it's not in our business to obstruct them. And with regard to, I was also asked why, whether we are able to trace financial inflows and outflows in our country. And the answer is in the affirmative. Except the cryptocurrency space, because of the reasons I gave earlier, our institutions of surveillance of financial flows are not at this point able to regulate cryptocurrency trade and transactions. And that is my problem as a security manager. That's where my problem is. And I know this puts me in direct conflict with other legitimate interests of commerce and trade and business and investment. But if, as a security manager whose responsibility at the end of the day will to be asked, why have the people of Kenya been harmed? This crypto thing, I need to know who is doing what, the source of whatever investment which is being put there, where it is going, and the entire chain. We must be able to regulate it. If we cannot regulate it, then it is, in my view, should not be allowed. And I say that with deep respect to the contrary opinions that we have received from those who think that this is a good thing. Then and was also even asked what the role of the Minister of Interior is in that surveillance. The Cabinet Secretary for Interior chairs the Interministerial Committee on Anti-Money Laundering and Counter-Terrorism Financing. And I've already held a meeting as late as 2 weeks ago. And this is a meeting where my colleagues, the CS for the National Treasury is a member, as well as the Cabinet Secretary for Foreign Affairs, as well as the Central Bank Governor, the Director General Financial Reporting Center, the Inspector General of Police, the Chief of Defense Forces, and all that. So we have a role. It is our business. But going forward, and that's why Parliament becomes important. Help us to clarify the law that we should use on crypto transactions. Leave the enforcement on us, because at the moment our hands are tied. And I really challenge Parliament to give us an act of Parliament in whatever shape, even an elementary act of Parliament that will give us the general space from where to operate. Then the Honorable Kaluma talked about the requirement for foreign companies to be registered before they operate in Kenya. I don't want to preempt investigations, but the question is whether this company was operating in Kenya, or whether a company associated with this company was operating in Kenya. And it's something that will come out perhaps as we go along. With Honorable asked about many issues around the kind of equipment which were brought into the country, I agree. Again, I agree with him to the extent that these are not scanning equipment, they are scanning and communications equipment, which brings into purview the role of the Communications Authority in authorizing that equipment. So again, investigations will help us, and I hope the reports of this committee will be part of what will help us zero in on who perhaps may have caused this lapse in terms of the type of equipment brought in, the payment of taxes, whether it was done correctly, And to the question of who is protecting these people, Chair, I don't know. The assurance I can give the National Assembly and this committee, through this committee, from where I sit, any person in government, out of government, in public sector, in private sector, who it is established, aided, abetted, supported, encouraged, or even attempted any of those things to facilitate any crime which may have been committed in the circumstances of the Worldcoin, we will hold them accountable. And that is the assurance I want to give as the security minister. We will hold them accountable. That is the policy framework upon which the DCI is operating. There is no one who is immune, nobody is excluded, and we have depoliticized our organs and agencies of national security to ensure that if people are found on the wrong side of the law, action is taken. It doesn't matter who that person is. Even if it is myself as the security minister, I will take responsibility. I will not be in a position at this point to tell the committee with certainty, 100% certainty, whether we retrieve and compel the retrieval of that data and by what time. But as I said earlier on, I believe it is possible. And I want to give the commitment of the government that we will go out of our way to make sure it is done. And perhaps a little more time, another 1-2 weeks, I should be in a position, even if I do not have to appear here, to provide a written position on where we are on this matter after I clarify 1 or 2 things. I will be more than happy to come back here, Chair, but the assurance is that even if I am not able to come back here before you complete your mandate, I pledge, as the law requires, that we shall implement all the recommendations that this committee and the National Assembly will recommend to the government. On behalf of government, we will implement all the recommendations 100%. Thank you.
Chair, may I just ask, Waziri, by what time do you see the investigations going on, ending?
In 2 weeks'
It
time.
would be of interest that in our report to Parliament.
In 2 weeks from today, or let me put it this way, by 30th of September, we should be able to at least have a preliminary output that can help us take action. But given the complexity of the matter, we'll continue to deal with these matters for a while. But at least I've been assured in 2 weeks from now, we'll be able to give a report that can satisfy, at least in the interim, the committee.
Yeah, thank you. Because Chair, our mandate is ending by 28th. And Waziri is generous. You know, in 2 weeks does not mean by 2 weeks. It may be even.
Can I ask if I can write as I can submit in writing?
Yes.
Some short progress report on investigations on around 25th. Is that too late?
No, it's not. And even actually the DCI, when they were appearing, they took undertaking of 2 weeks, and our report should be tabled on 28th. So by 28th, by Friday, by 25th
25th. I promise to do
or
so.
24th.
Or 24th,
Yeah,
because also you have to do report writing.
exactly.
All right, today is 15th, Chair, is what is? 24th is a Sunday. What is the Friday preceding?
That one is 23rd.
I will supply the committee with where we will be by 23rd, close of business.
Thank you, sir. Yeah, it's actually 2:15. Maybe just one word. You know, your colleagues have really done a good job.
Yes, indeed. Bwana Mwenyekiti, ukiniruhusu naomba mwanzo nimpongeze waziri kwa kazi nzuri anayofanya, na hapa amekuja kwa kamati inaonyesha vile yeye ni msafi kama pamba, kwa sababu hakukataa hawa watu wanahabari kuingia ndani, kaona waingie, Wakenya wajue kile kinachotendeka. Asante kwa hilo, na sijasema kwamba wale ambao walikataa wanahabari si wasafi, lakini hapa umeonyesha ule ujasiri na kutaka mambo yawe wazi. Naona ni vizuri vile tahadhari unazozichukua kama waziri wa usalama, maanake sisi tunaishi maeneo ya Lamu, tunajua yale mambo yanayotokea ambayo tunazuia asitokee. So nimefurahia hivyo, na sisi kama kamati pia tuna hizo tahadhari. Bwana Mwenyekiti, nataka nichukue nafasi hii niwajulishe kwamba jana tulikuwa Lamu na waziri, na kazi ile amefanya katika miaka kutoka tupate uhuru hatujawahi fanyiwa. Kwa hivyo asante sana, endelea kufanya kazi mzuri na Mungu akubariki. Asante. Ile affirmative wengine walikuwa hawaoni affirmative, sasa hivi sisi ndio tunaambiwa kuna watu wanatambua affirmative. Asante sana waziri, shukran.
Thank you so much for the compliment. You know, we should be Gideon. In 1 minute, please. Yeah. Because we should be also in the house. There are two important businesses.
Okay,
Yeah.
thank you, Chair. Just 1 minute. Waziri, my question pertains to an agency in Eldoret. There's an agency in Eldoret called First Choice Recruitment Agency. This agency is owned by somebody called Judy Chepchirchir. All arms of government is kind of, they have been unable to touch that lady. There is an investigation by the Senate. The AG came to the Senate, promised the Senate that the Labor Committee in the Senate that action will be taken. Nothing so far. The agency is still continuing to recruit members, public, lying to them that they'll take them to abroad, specifically Qatar, UAE, and Saudi, and some to Poland. Myself, members of my family were part of that, who are called. But when I made noise in August, members of my family were refunded. But in my own constituency of KO South constituency, I have 76 members of the public. Some 100,000, some 200,000, some 40,000. But when we make this noise, there is rumors in Eldoret, because the people who have been duped by this lady are from Elgeyo Marakwet County, Wasingishu County, Nandi County, and some majority from the 3 counties. And then the rest in Nakuru and Trans Nzoia. When we make noise, there's rumors in Eldoret that this is a deep state, that she's untouchable. Some of us who have made some little noise, some people threaten us that there's nowhere you'll go. As the Minister for Internal Security, if myself as a member of parliament, I'm making this noise and nobody can listen, what about that member of public out there in Eldoret? Who is Judy Chepchirchir? When there was the issue of taking people abroad, she was paraded around as the person to take people abroad. that she will lead the government policy on the issue of labor abroad. Waziri utusaidie. Asante.
You can address to
Thank you. Chair, I forgot, in 1 second, I forgot to answer the question which was directed at me on whether there is a contradiction between what the director of the criminal investigations said about the departure from the country of the officials of Worldcoin and what I have said here. And I want to confirm to the committee that there is no contradiction. It is true that the police, through the DCI, had effected stop orders against the concerned people, and they had filed those stop orders with immigration, and we had placed a red alert. And it is true what the DCI said when those officials attempted to leave the country. I can't recall which day it was, but sometimes last week, around 10 p.m., they were prevented and they were taken to the custody. But I've already said that there was intervention, diplomatic intervention by the government of the United States of America. And the two governments reached an understanding that instead of detaining these people when we have not arrived at a point where we have established that they have committed crimes, they should be allowed to leave the country. And the government of the United States of America has pledged to surrender these people if they are needed. So it is true what the DCI said is true. And I was personally involved. And therefore I want to take responsibility and also assure the country that when those people are needed, we'll bring them back. If they are needed, they will come back. And then I have been asked to, because one was a compliment from the member of Lamu East. Thank you, thank you very much. The last one by the member for KO South. If a complaint has been lodged in a police station about the possibility of a crime having been committed around that issue, I would ask for 3 days to respond to that matter in writing to the member or to the committee, because it's been asked through this committee. But if a complaint has not been done, we don't interfere with the working of either other arms of government. This matter is a labor matter, but if it has security implications, just like this matter, it was not a security matter, it was a trade commerce issue. But if there are security matters and an OB entry, a complaint has been lodged in a police station anywhere in this country, let me know. I will follow up and I undertake within 3 days to respond and to the satisfaction of the member, the committee, and the public. Otherwise, we don't interfere because we can't run. The Ministry of Labor have their mandate, other ministry have their mandate. We only come in when offenses have been committed and when a complaint has been lodged. Thank you.
So thank you so much, Waziri. We need to come to the end of this. And just one matter before we conclude. It is a little bit out of the Worldcoin. When Waziri, there is, it just come to our knowledge that there is something like a majority in the northern part of the country, some clans who are coming up with their flags. I don't know whether you're aware. Mostly in the Muslims communities in the northern part of the country. Every clan is coming up with a flag, a flag, a flag. We don't know what that is supposed to mean. I don't know whether it has been brought to your knowledge. And it's something that as Kenyans, specifically myself as a chair of security, it is brought to our attention and is a matter that I think should be of concern to the ministry.
I'll take it up. I know there are serious clan-related tensions in northern Kenya at the moment. As to the issue of flags, again, one would look at the relationship of those emblems to the contribution of mobilization of the insecurity that we are experiencing. There are actually active clan conflicts which are taking place even as we speak. Initially Garissa, now increasingly Wajir and Mandera. So something I can take it up and see the relationship, and thank you, Chair, for bringing this to our attention. But we have already captured it and we are handling it. And hopefully on Monday, I'll be in Northeastern and that will be part